Let's talk about what a settlement agreement must contain. First, it has to have the name of the original lender, the bank with whom you originally took out the card and owed the debt to, or the debt purchaser who now owns your debt. If a debt purchaser now owns your debt, don't forget to go through all of those steps that I outlined in the earlier video on debt collectors about how to do your due diligence on tracking down exactly who that debt purchaser is, getting a validation from them that they own the debt, having an attorney or private investigator look into the company to make sure that they are legitimate, everything that you need to do to protect yourself to make sure that the person you're about to send money to is really the person who has the right to settle this debt for you. I have never had debt go so long that a debt purchaser called me about it. All of my settlements and all of my reader settlements that I know of were with the original lender or a contracted collection agency. But in any case, whoever owns your debt, whoever you are settling with, their name needs to go on the settlement agreement. Also, the name of the contracted collection agency, if there is one working on your original lender's behalf, along with their actual address and phone number, need to go on the settlement agreement. Your full name as listed on your account should be seen clearly there. Your account number, I recommend the full account number so there can be no confusion, though I have had instances where the settlement agreement came with the last 4 digits of the account. Again, check with your bankruptcy attorney, who I always recommend you run your settlement agreements by, just to make sure that they are legal for your jurisdiction, your city, or your state. But generally, I think you would probably not need to go back to the collection agency to say, put in the full account number if only the last 4 digits are there, though I recommend the full account number. The total balance of the account, meaning the entire dollar amount that you are settling, which would be the original balance plus all interest plus all fees. If it's just the original balance and they're trying to tell you that interest and fees is something else that's not part of this settlement, that is not the agreement that you settled on. The total amount that you are settling, so that when you are done, there is no debt left to collect and no collection attempts will be made further. The settlement amount, usually not listed as a percentage here. You don't need it to say 38% or 33% or 45%, just the dollar amount to 2 decimal points of cents if necessary, the actual figure that you will be sending them as settlement in full. Also, words that clearly state something to the effect of the payment is being made as settlement in full or full settlement of. If those words aren't there, it could be interpreted as just making a payment against the balance on your account. I highly recommend again that you have your settlement agreement read by your bankruptcy attorney to make sure that the phrasing is adequate to him or her, that you are getting that protection, that term that you have negotiated for. As we discussed in one of the previous videos, you need to have whatever terms you agreed upon for the payment of the settlement amount, whether it's upfront, all at once, payment in full, or a structured installment plan, how many installments there are, when each payment must be received. If it says the first of the month at 10 a.m., you want to make sure that there's an exclusion in there for Saturdays, Sundays, and holidays. You want to make sure that this legal contract expresses the terms necessary that you can abide by to make sure that it is not nullified if you miss something that you didn't know about. And a signature from a responsible party, whether it's the debt collector you've been dealing with or his or her boss at the collection agency or someone at the bank itself. You want it to be a legal document that's signed. Some of my agreements required me to sign. Others didn't require me to sign, only to send payments. Ultimately, from their point of view, they don't need your signature. All they need is your payment. If you make the payment, you've lived up to the agreement. And if you don't make the payment, you haven't. You're the one who needs the signature because you're the one who needs the term of settlement in full that you can prove in court if you ever need to, or as I did when a collection agent tried to collect on the balance of an account. If I had a settlement agreement in writing that wasn't signed, they may have said, well, somebody sent you this agreement, but we never agreed to it fully, so you sent the payment, and now you have to pay the balance. You need the signature more than them. Again, I will say, have an attorney review your settlement agreements. You're dealing with a legal process that will relieve you from the necessity to pay a debt to a major banking corporation. It is in your best interest to pay the hourly fee to have an attorney review your settlement agreements. I would have my attorney review all of my agreements. I can't recommend highly enough that you do the same. And then here I share with you several of my settlement agreements. You will note the $76,000 settlement for $25,000, the $18,000 settlement for $7,000, the $21,000 settlement for $7,400. The thing that I want you to do now is not just look at the settlement amounts. We did that earlier. Now I want you to read the documents. I want you to notice how they are not boilerplate. They are not all written exactly the same. They all have slightly different phrasing, slightly different terminology, slightly different ways of expressing the same thing. Even that line on settlement in full or full settlement of comes across differently in the different agreements. One says full settlement and release of the account. Another says final settlement of this account. A couple say settlement in full. One says this will release you of further obligations regarding this matter once funds have been cleared. So this sentence is going to be written differently in your different settlement agreements, which is again why I recommend you have an attorney read it over to make sure that however your bank phrases it says what you need it to say to make sure that it is enforceable.